Okay, I hope my screen is visible. I hope I am visible. All right. Mm, can someone please let me know if I'm visible and my screen's visible and I'm audible and everything is okay?
Yes, ma'am, you are visible.
Yeah, everything is okay.
Thank you. Thank you. Okay. So, I don't know how many of you all have gone through the subject company law, but Memorandum of Association, which is in short called MOA, is governed by the Companies Act of 2013. So, Memorandum of Association is okay. So, Memorandum of Association, basically, before we dive into what it is, we will look at the some definitions which are provided by certain um, authors, certain thinkers, and as well as the Companies Act of 2020. So, as we so this is a common consensus that your section 2 of most of your acts are your definition clause, is your definition clause. All the definitions, every word that you might get confused with are all defined in section 2 of every single act, mostly 90%. So in Companies Act also, section 2 is where all of your definitions are. And since Companies Act is a lot more newer in comparison to most other acts, certain terms and certain phrases and certain words are not very familiar to a lot of people. So there are a lot of definitions in section 2. So section 2, clause 56 of the Companies Act of 2013 states that a memorandum means the memorandum of association of a company as originally framed or as altered from time to time in pursuance of any provisions of this act or any previous act. So as we can see, there is not much clarity as to what a memorandum of association means in the Companies Act. Therefore, we try and bring in certain authors to try and understand the meaning or what is a memorandum of association. So two of my most favorite, the definitions that I've seen. One is Palmer's definition. One is Lord Macmillan's definition. According to Palmer, a memorandum of association is a document of great importance in relation to the proposed company. Very easy, super simple. It is to the point, but again, it does not say what a memorandum of association is. In contradiction, it just says that it's a very important document which is needed in a proposed company. Lord Macmillan, on the other hand, he has elaborated, or he has tried to give us a lot of things which can be included in the memorandum of association. So he says that a memorandum of association sets out the constitution of a company. It is, so to speak, the charter of the company and provides foundation on which the structure of the company is built. Importance of memorandum lies in the fact that it defines scope of company activities, its relation with the outside world. Its purpose is basically to enable the shareholders, creditors, and those who deal with the company to know what are the permitted range of activities. So basically, in short, memorandum of association outlines the company's objectives, powers, and scope of operations. Okay, and someone asked me what's the difference between a MOA and AOA. MOA is something which is to do with inside the company, as in your constitution, your powers, your functions, become, which is just related to the company. There is no outside world involved. Whereas in an article of association, it contains, so basically, memorandum of association is how the company is governed, and articles of association is the minute management details of the company. Memorandum of association includes the scope of companies. It is like the constitution of companies, and your AOA are your other sub laws of your companies. Like for example, to make it simpler to understand, your memorandum of association is can be compared to the Constitution of India, and your articles of association can be compared to your other acts like IPC, CRPC, everything else, like everything else under it, your Narcotics Bureau Act, your anything and everything under the sun, which helps in the minute management of India as a whole, is what these other acts are. In the same way, articles of association also are those kinds of is that particular document which contains the rules and regulations for the internal management of the company, like how an individual can be hired to the company, what are the salary packages for certain sets of people, etc., etc., etc. So articles of association is very, very different from memorandum of association. Please don't get confused between the two. Next, okay, so the nature of MOA is that it has certain boundaries that it needs to be under, and if it exceeds those boundaries, it is considered as ultra virus, that is beyond the power. Now the power that is given to the memorandum of association is also given through the shareholders. Now the shareholders are given power from where? The Companies Act. Companies Act gets its force from where? From the Parliament, because it's a state law. State in the sense India. And next, once an MOA is registered, it becomes a public document, and any person can ask for an inspection of the document and can also have a certified copy of it. Now, the object of this is to protect its shareholders, creditors, and outsiders who come forward to have contact with the companies. So, since MOA is registered and it's a public document, and as we all know, company is just it is not a natural person, but in company law, it is considered to be an artificial person. It has certain characteristics which we won't get into because it will take a long time, like 2 hours, 3 hours. So we won't get into that. Just know that a memorandum of association or the once an MOA is registered, it becomes a public document which can be inspected by anybody, and they can also apply for certified copies of it. Like how in the court you apply for certified copies, in the same way, there are certain prescribed formats as to how you can get a certified copy of the MOA. And this happens why? So that before any shareholder or any creditor or any outsider invests in the shares and invests in the management of the company, they know what the company is about. Ramakishori, please mute yourself. Okay, so the purpose of MOA basically has two purposes. Firstly, the prospective shareholders can know the fields in which their funds are going to be used by the company and the purpose for which the enterprise, so that they can contemplate the risk involved in their investment. Secondly, outsiders dealing with the company can know the objectives. Your shareholders and your outsiders, both of them need to know. That is the main purpose why we draft an MOA. Moving on, there are importance of an MOA. So does anybody know what are the importances, like why an MOA is important? Okay. Okay, I'm going to tell you. So basically importance of MOA is basically that it helps any individual know what the particular status of the company is, that is the legal status of the company is. So that since it's a legal document, it gives everyone the know-how of how the company works. Secondly, it defines the company's purpose, everything related to the company, from who are its directors to who are its promoters to everybody and everything is mentioned in the MOA. The verified capital, how much it is, how much capital does the company have to have with itself before it actually registers itself as a company. So next, it defines the company's purposes. It protects the interests of the shareholders, whereby since it's a public document and they are able to inspect it anytime they want, they are able to figure out as to when, what, and how, and where their money. Shareholders are people who are basically investing in the company. So they have the right to know where their money is going and how the company is utilizing their money and for what purposes and what reasons. Next is to facilitate capital raising. The MOA, as I already told you, it specifies the authorized share capital of the company, which helps the investors to understand the potential size of the company. Now, most big companies deal in crores, like 100 crores, 200 crores. That's their authorized capital. So the potential size of the company can be determined by your capital, like how much capital you have in reserve. Then, so if during issuing of shares, your MOA is what comes into play, wherein your MOA as well as the prospectus is issued to the public, and they ask for investment via shares. So that's where MOA helps as well. Okay, moving on. The form and procedure of filing of an MOA. This is mentioned in 1 second. Okay. Section 4 of the Companies Act 2013 basically mentions the form and procedure of filing an MOA. Okay, so the form of the MOA is basically the MOA shall be in such one of the form in tables A, B, C, D, and E in Schedule 1 of the Companies Act 2013, as may be applicable in the case of a company, or in a form as near thereto as circumstances admit. So basically what it means is there are certain tables in your Companies Act under Schedule 1. Now, Schedule 1 basically specifies certain kinds of forms as to how a company's MOA is supposed to be. Keeping that in mind, your promoters and your shareholders, they draft the MOA. And then the procedure for filing of an MOA is that on the registration of MOA of the company registers. So basically, you file a copy of it as well as the originals to the company registrar. The company registrar will verify, will check, will go through, will try to understand, will cross-verify multiple times. If they have any questions, they will ask you about it. And once he is satisfied, he puts his seal, he puts his signature, as well as he enters all the particulars. As far as I know, company registrar has a diary or like a big freaking register, a big register wherein they mention the name of the company, the date in which it was incorporated, the verified capital, who are the shareholders, as well as have they submitted all the forms as is required for a company to be registered as a company, and subsequently have they filed an MOA, have they given an AOA, have they started functioning. All of that is all mentioned in a register which the registrar of company has. Moving on, section 4 also has the contents or clauses of an MOA. So every MOA must have these clauses minimum. Apart from that, you can always have extra clauses. So the first one is your name clause, wherein this clause specifies the name of a company. Okay, so for clause 1 basically talks about name clause. Okay, so the name clause basically states that how the name of the company can be. Name clause of an MOA basically includes the name of the company, wherein, for example, if I start a company, I have to make sure that it aligns with everything that is provided under section 4 clause 1. Now, there are certain undesirable names which are to be avoided. Now, for that, you need to look at the emblems and names Prevention of Improper Use Act. It must not be, number 1, it must not be suggestive of any government patronage or protection to the company. Number 2, it should not have the word cooperative. Now, cooperative societies and companies are two completely different things. And if a company has a cooperative at the end or at the beginning, it is not considered a company. It is considered as a corporation. So also, very recently, the non-governmental companies or enterprises are prohibited to use the word national in their name, because national basically specifies something which the state controls. Like, for example, that there are many corporations which are owned and controlled by the state, which are wholly and solely under the state corporation. Only those or government companies and government enterprises are allowed to use the word national. Apart from that, private companies, like for example, me and you establish a company, that cannot have the word national in it. There are certain things which you go through the emblems, name and protection, emblems and names prevention of improper use act. You will get to know that there are certain names and there are certain things which or emblems which are suggestive of any government patronage. They're not allowed to be used by private individuals. Moving on. Okay, so broadly speaking, any name which is undesirable is rejected is either on two grounds. Number one, if it is very similar to the name of another company. For example, let me give you an example. Okay, if there was ever a conflict between AirAsia and Air India, okay, so their names start with the same word. The next letter, that is A and I, is what is different. So your name does not have to, must not be completely same as the name of another company. For example, I established a company named ABC. Now, another individual cannot establish the same company if my company has been registered before his company is even come into existence or is even registered. And the second one is misleading. That is suggesting that the company is connected with a particular business, that is, or that it is an association of a particular type. For example, if I start a company saying ABC Technologies, okay, so the first thing that will come to your mind is, okay, this company deals with certain technologies. What they are, we need to find out, but we know it deals with certain technologies. Now, for example, if I've kept the name of my company ABC Technologies, and I go ahead and start tuitions, which is completely different to what my name is, and it is not connected to any kind of business that I'm doing, it is not desirable, and therefore the name is rejected by the registrar itself. Now, so registrar is also human, okay, and humans make mistakes. And in case two companies have the same name, which are registered by the or which have the authentication hand and seal of the registrar, one of the companies or both of the companies can apply to the courts, wherein the courts will actually look at the history, will look at which was incorporated first, will look at which company came into existence first. They will let them have the name, and the other person's or the company which has come in second, their name will be rejected, or their name will have an injunction to use. Injunction as in to stop. Injunction, so they will be barred from using the name, and if they still continue using the name, the other company is liable to send a notice demanding to stop, and then further complicated actions or suits can be filed, and they fight it out in the courts of law.
Excuse me, ma'am.
Yes.
Ma'am, will you please explain the misleading point once again?
Okay. For example, misleading is, okay, so I have kept the name of my company ABC Technologies. What would be, so if I heard the name ABC Technologies, the first thing that would come to my mind is, okay, they deal with certain kinds of technologies, might be computers, might be phones, might be software, might be hardware, one of those things. Now, if I start a company named ABC Technologies and I go ahead doing construction business, right, which is completely different from what my name suggests, it is misleading. That is, I am trying to tell everyone that I'm a technology company, but I am doing construction business. That is not good, and that is very misleading, which it is misleading to the public, it's misleading to the shareholders, it's misleading to the outsiders, it's misleading for the registrar of companies, and it's misleading for the entire government as a whole. So kinds of names which are misleading, they are completely avoided. I hope I've cleared it out.
Yes.
Anyways, okay, so these are certain, case laws if you want to go through to understand company or the name clause of a company. So the Memorandum of Association also states the name of the company with limited or private limited as its last word or last. In case it is a public limited company, you don't have to put the word limited in case the company has been formed for the promotion of arts, science, religion, etc., the central government may, by license, provide for the omission of the word limited. Like, for example, we all know of this association called the Rashtriya Samaj Seva Sangh, right? RSS. So that it is a private organization. It is not a government organization. Please don't get confused. RSS is a private organization. And because it applied to the government saying that it is for the promotion of certain kinds of religion, certain kinds of, how do I explain it? So certain kinds of things which are good for the development of a human being, they have applied to the government and the government has given them a license that, okay, you don't have to include the word limited or private limited in the name of your company. Now, if RSS was registered, it is not. If RSS was registered, they would be, if they applied, they could have asked for the removal of the word limited or private limited. And since it's not registered, again, please don't take this in the wrong way. I am just trying to give you an example. I'm just trying to explain to you so that it's easier for you to understand. Since we know of all of these names, is why I'm trying to give you examples which are relating to certain names. I'm not biased towards anyone, so please keep that in mind. Okay, so okay, for example, in Bangalore, in where I stay, there is this place called Chitrakala Parishad. So so basically it is a fair, or it's a place where the promotion of art and the promotion of artists is very, 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 very widely promoted, right? So and it is a company. I do not know if it is registered or not, but it is a company. It's a private owned company, and they have a building and all of that, and they have their office clause, etc., etc. But had they applied, I'm not sure if the company is registered. I'm just giving you an example. If the Chitrakala Parishad wanted to get registered, they can, or they have the authority to apply, because they are for the promotion of certain arts, and they can apply so that because when you have a very Indian sounding name which does not have any traces of English in it, like for example, Chitrakala Parishad, what do you understand by it? It's something related to art. People who know the language might be able to understand. A foreigner who does not know the language will not be able to understand what that particular word or the phrase means. So to 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 make sure it is specified for the promotion of certain arts or certain sciences or certain religions, the word limited is removed so that it has certain it so basically it's not for the it's not profit motive. It is basically for the promotion of science, art, and religion. Now, publication of a name, every company. So these are some things that you need to do after your company's MOA has been accepted. You need to publish your name. Now, every company shall plan to fix its name and the address of its registered office on the outside of every office or place in which its business is carried out. Now, for example, I own an ice cream franchise. I have registered my company. I have multiple branches, one in Bangalore, one in Delhi, one in Haryana, one in, let's say, Mumbai. Now, if my main branch is Bangalore address and the name of the company in Bangalore needs to be in every single one of those locations, right? So that is something which needs to be published. Second one, it needs to be engraved in the legible characters of its seal. Now, every company must have a seal, right? Or anything which they sign their official documents, like a seal. A seal is used because company is an artificial person and it goes on for times immemorial. The people might change, but the company goes on forever. There's this phrase which one of my company law teachers used, which is people may come, people may go, but the company goes on forever. So the fact that the company is in existence will remain for as long as the company is existing and it's not amalgamated or it is not closed down. But the people who are, holding authority over the company, they might go, they might come. So just so that the company's identity is maintained, you have a seal, and your name of the company must be engraved in the seal. If you see, even when you go to get your documents notarized, every notary has a seal. It's 90% of the time a round seal, wherein the name of the notary, whether the fact sheet, if he is a private notary or a public notary, and where his office is, like for example, um, all of that is actually mentioned in the seal, and then they use the seal and they seal every single paper that you want to get notarized. Third one, it must have its name and the address of its registered office mentioned in legible characters in all business letters, billheads, negotiable instrument, invoices, receipts. Now, if you go to any big, just 1 second, guys.
Ma'am, I had a question actually, if you would be willing to answer it.
Yeah, tell me.
So a private organization is automatically assigned with the word limited at the end until it chooses to apply to the government to remove it, right?
Only if it is for the promotion of art, science, or religion, or certain
Okay.
things which are